Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Consumer Protection Bill 2015. To discuss the issue, I have with me Mr. Kamal Khan Jaiswal, former civil servant, President, Common Cause, former Secretary, Government of India, and Mr. Sanjay K. Chadda, advocate. Now for the headlines. The Consumer Protection Bill makes manufacturers or service providers liable for personal injury, death or damage to consumers. The bill proposes to set up a regulatory body with the power to recall products and initiate action against defaulting companies. Non-compliance can attract fines up to Rs 10 lakh. The Consumer Protection Bill makes manufacturers liable for personal injury, death or property damage to a consumer. Any consumer seeking redressal against a manufacturer of a hazardous product can approach the court and make producers liable for damage and send them to prison for life. The proposed consumer bill proposes to replace the existing consumer law.
The existing consumer law could not provide the consumers the sort of protection it should have after widely used Maggi noodles were found to contain lead, which is harmful. Consumer Protection Bill 2015 seeks to make manufacturers liable if their products or services cause personal injury, damage or property damage to consumers. According to the bill, it will be the responsibility of a manufacturer or a vendor or a goods or a service provider to compensate consumers for injury or damage caused due to the defective product.
Implication is initially if I bought some product and it is defective, then I as an individual had a right to claim the refund or damages whatever. Now the government can step in and say that the entire product is hazardous or not performing well or any bad element is there. So government can say that now you compensate the entire class.
The bill proposes to set up a regulatory authority which will have powers to recall products and initiate class action suits against defaulting companies, including e-tailers. The bill empowers the Central Consumer Protection Authority (CCPA) to act on its own on matters that violate consumers' interests. The bill allows CCPA to recall or discontinue products found to be unfair or prejudicial to consumers' interest. It will be the duty of CCPA to make the use of unique and universal goods identifiers to prevent unfair trade practices. The Central Consumer Protection Authority has been empowered to order withdrawal of advertisements found to be false or misleading. Those who fail to comply with CCPA's order will be liable to a penalty up to 10 lakh rupees. The authority can also declare terms of contracts found to be in unfair trade practices by any manufacturer as null and void.
The existing intermediary liability framework under the country, particularly after the judgment of the Supreme Court in Shreya Singhal. People mostly associate the decision with Section 66A, but the concluding portions of the decision actually deal with the aspect of intermediary liability, in particular Section 79 of the IT Act or the Information Technology Act, which goes on to categorically exempt intermediaries from any liability of any kind under any law, subject to certain conditions being satisfied. So I fail to understand how can you hold e-commerce entities liable when all they provide for is an e-market platform for sellers and buyers. So that's something that needs a bit more of thought, although I haven't seen a provision so far which perhaps reflects the sentiment.
The proposed amendments of the bill have come in the backdrop of the emergence of complex products and services in the era of growing e-commerce business in India that has rendered consumers vulnerable to new forms of unfair trade and unethical business practices. Consumer Protection Act 1986 was enacted to provide for better protection of the interests of consumers and for the purpose make provision for establishment of consumer councils and other authorities.
Consumer activists want the government to make a provision to prescribe a fixed time limit for disposal of cases that come to consumer forums. As on today, the provision is not there in the bill that is proposed by the government. With camera person Vijay, Raj Kamal Rao, Rajya Sabha TV.
With penalty of up to Rs 10 lakh, the proposed bill could help the manufacturers and service providers become more accountable and make them serious about consumer interests. Is that so, sir? The penalty as it exists today, did it exist in the same manner earlier? Or has it been enhanced a bit?
It's been enhanced.
To what extent?
It's been enhanced. I would not be able to recall the exact figure, but it's been enhanced, and it's one of the major changes that has been effected. But I would first like to, in some broad sweeps, talk about the motivations behind this legislation, the proposed legislation.
Yes, sir. The accountability part, where you said there is no attempt to make the new entities that have evolved accountable. The definitions, as you said, have been brought in,
right?
But the way it should be weaved into the law, that has not happened.
Quite
correct?
Right. Quite right. Now, one of the major reasons for undertaking this new piece of legislation is that a lot of changes have taken place in the 30 odd years of operation of the existing law. Changes have taken place in the marketplace. The way commerce is transacted has undergone a sea change. So the new new legislation is supposed to factor in those changes and achieve the objective of consumer protection in the current conjuncture. So one major change that has taken place is the emergence of e-commerce. And the meteoric increase in its reach and its scale and its
But as Mr. Sai Deepak was saying, he's an advocate. He represents, I think, Flipkart or Snapdeal in one of these.
Right.
He said that the e-commerce entities have actually been made liable.
No, but then what is the liability? What is the liability? For instance, the new category that has been recognized in the definition clause is that of electronic intermediary. The electronic marketplaces like Snapdeal and Amazon, Flipkart, and
so many of them.
So now their liability in respect of the due diligence that they have to exercise, so that the consumer
that has
not been addressed.
It is not reflected.
Do you agree, Mr. It is the
what I feel as first thing you asked, that what is the provision of that 10 lakh. I would say even in the current system, not 10 lakh, the authority, the National Commission, the State Commission, they have authority to impose even greater fine.
They
more than that,
ask the entity to pack up.
Pack up. They can do anything. I mean, they have to recall. All those powers are already existing. As this new 10 lakh penalty has just been stated. That is on the advertiser.
It's a limited
opt for advertiser of that too food product, which is injurious to the humankind.
Correct.
That is one. That is specifically they have provided, and that too suo moto, that action
on its own it can take on.
That is one. As far as the current scenario is concerned, under the current scenario, if a consumer suffers, he approaches the court. Court means commission, let's say National Commission or a State Commission. There, the State Commission or the National Commission can even go beyond 10 lakh.
No,
even in the current scenario.
But the point sir is making is that the element that the new entities, the e-commerce entities, must get into due diligence on their part to ensure that the platform that they are providing to sell the product is not happening and has not been reflected in the bill.
Yes.
Do you feel the same?
Yes, that is there, because everything cannot be incorporated, because if you go the e-commerce, the global business which is expanding day to day, day and night it is expanding. It is almost impossible to incorporate each and every point specifically. That is the reason, in a broader term, that power is given to the commission or the body which is incorporated.
So the authority and the state level authority and the district level consumer court, according to you, has been empowered to such an extent that they will have or inherently have that power to take and force these entities to get into due diligence.
Yes, that is what is happening. I give an example here. Even these days, when this bill is not existing, National Commission, State Commission, District Forum, they are regularly accepting cases on these entities like Flipkart, Amazon.
Correct.
There are n number of cases going on right now also, because there is a provision, they come under the broader provision, and the judges who are there, they take interpretation from the provisions which are already existing.
So what you're saying is it's a good step forward, but what sir is saying is more needs to be done. Correct, sir?
That's right.
But do you agree with the point that what's wrong with the consumer courts? I mean, do you really need to codify or write down everything in specifics? Or you can allow the system to use its own intelligence with an overarching kind of a legal framework that has been provided to it, and then evolve on its own and have a better law?
I agree with Mr. Chadha. To a certain extent, the courts, through their interpretive power, can supply the lacuna in the act. But then, when you state it as the avowed objective, that you say that these changes have taken place and hence the new the need for a new legislation, and then you omit this vital function, then that I think
correct. I get it. So you state it as an object,
yes,
and then you don't provide for it.
Otherwise, you don't need a codified law. You can give unlimited powers
to the courts and allow it to evolve.
And England has functioned for a long time without a written constitution.
Correct.
So,
it's time for us to head into a short break. Coming up, the bill proposes to introduce mediation under the umbrella of consumer court as an alternative dispute resolution mechanism. Welcome back. The Consumer Protection Bill 2015 recognizes mediation as an authentic dispute redressal mechanism. The government has introduced this provision to give legislative basis to mediation by making dispute resolution simple and faster.
Consumer markets of goods and services have undergone drastic transformation since the enactment of Consumer Protection Law in 1986. The modern marketplace contains a plethora of products and services. This has rendered consumers vulnerable to new forms of unfair and unethical trade practices. Misleading advertisements, telemarketing, multi-level marketing, direct selling and e-retailing pose new challenges to consumer protection that require appropriate and swift inventions to prevent consumer detriment.
A serious issue, I think, with respect to the proposal for a mediation mechanism. Mediation may be an option, but unfortunately the fact of the matter today, the ground reality today is that mediation has become the de facto norm in most consumer protection forums. And I think this is perhaps at the expense of hurting people. I would actually like to say that this is abdication of judicial responsibility.
The bill proposes to introduce mediation under the umbrella of consumer courts as an alternative dispute resolution mechanism. The bill proposes to establish consumer protection councils and other authorities for timely and effective settlement of consumer disputes. The bill enhances the limit of district consumer forums to adjudicate matters worth 50 lakhs from existing 20 lakhs to reduce the burden on state and national level forums. The bill proposes to establish Consumer Protection Councils (CPCs) at centre, state and district levels to protect consumer interests. CPCs will be headed by Minister in charge of Consumer Affairs at state and central level, and District Collector will act as the chairman at district level. The bill empowers the Consumer Protection Councils to protect consumers from marketing of goods and services which are hazardous to life and property. CPC will ensure access to a variety of goods and services at competitive prices for all consumers. The bill also makes it responsible to provide redressal against unfair trade practices, unscrupulous exploitation of consumers.
orders passed by the consumer courts or the forum will be enforceable as a decree of a civil court. So that gives more teeth to the consumer courts. They can enforce that decree. Initially, it was being taken very casually, first. Secondly, there is an introduction of element of mediation. That is again good because mediation is now a formal arrangement wherein some technical people, some advisors advise both the parties to the pros and cons of the litigation and make them to agree, suggest them to agree. And if they agree, then the litigation is sorted out in a congenial manner. And in a way, it's good.
The bill seeks to widen the ambit and amplify the scope to modernize the legislation on consumer protection to keep pace with the changes in markets. This is needed to ensure fair outcomes of consumers, allowing swift executive intervention in the nature of class action and both to prevent consumer detriment. The bill will replace the existing Consumer Protection Act 1986.
Lack of infrastructure facilities in all consumer forums across various districts in the country could pose a challenge when the government passes the bill in the parliament. Many of the consumer forums do not have adequate infrastructure to dispose cases on time. With camera person Vijay, Rajkamal Rao, Rajya Sabha TV.
So several changes. You've got mediation, you've got original jurisdiction expansion, then civil court powers to the consumer courts at the district level, and most of all, specific accountability fixed at district level, that of district collector, state level, that of the consumer-related minister, and at the center level of the consumer-related minister at the center. Now, sir, this is very, much more evolved with suo motu powers, unlimited powers, class action suits. So, compared to the earlier law or the existing law that we have, it is an evolution. But you say that the gaps that exist, the deficiencies in the other law, for example, providing district forums which have not yet taken off, have not been addressed how that is going to happen, correct?
Right. So, my problem with this, the objectives are laudable. The objectives are laudable. My problems arise at the pragmatic level, at the implementation level. If 30 years experience shows that district forums could not be operationalized to the optimum extent, then what is the cause for optimism in respect of the functioning of a parallel structure that is being put in place? You see, you have this...
was the district collector the head of the consumer court earlier?
The district collector, because I have been through that
I know, sir.
Evolution.
You're a career
so district collector, as it is a very overburdened functionary of the state.
Yes.
Now, associating him with consumer matters also, I don't know how much time a district collector would be able to find.
Okay, so we have a problem at the district level.
We have a serious problem there. We have a serious problem there.
That way, even at the state level, the consumer minister will have a problem finding time.
Consumer minister is in charge of consumer affairs. He doesn't have other responsibilities. So that might not be a problem. But at the district level, and you know, the cutting edge is the district level.
Correct. That's where the problem...
That is where, if you are merely transferring the problem from one end to another. So, in my idea, it would have been better to, first of all, empower the district forums and the state forums which were there, the commissions already, give them the necessary infrastructure, give them the human resource that was required, and also confer on them the powers which are now being sought to be conferred on an entirely new entity.
Correct. Sanjay, you would like to...
the regulatory authority. Because if you just give me half a minute, because it is possible to have one entity performing different functions, related functions. So you already have infrastructure in place. All that you need is to shore it up, strengthen it further, and give additional powers. Then have one uniform consumer protection agency, which would do grievance redressal, dispute resolution, also exercise the regulatory power, because there is certainly a lacuna in the existing act insofar as the executive powers are concerned.
A lot of tools have been given to various entities across the board.
Now, I differ here, because under the new act, we have formed 3 bodies actually. One is council,
correct,
other is CCPA, and the third is, which is already existing, the commissions and district forums. First is council, is where you just said district magistrate, district administrator is the head of at district level. Second is state level minister is the head, chairman, and at the central, those are councils.
Correct.
Those councils are not giving actively, every day to day. They are just broadly supervising and monitoring the difficulties which the consumers are doing. They are particularly looking into the R&D work. They are promoting NGOs. So their work is not that they have to do it every day. They are broadly monitoring it. That is one. Then second is CCPA, which is the origin of the new bill. Wherein a central body is created, only one body is created, where the chairman of that body is secretary level. Secretary at his level is secretary in the government of India.
Correct.
That is one. No, he's secretary at government of India. His level is secretary government.
The rank is of a secretary.
Rank is of,
but the name will be a commissioner.
Designation is. Then under him there will be few deputy commissioners who are of the rank of JS, Joint Secretary. So what is their purpose? They have been, this is the new body which is incorporated, which is new body which is formed, proposed to be formed, and that is regulatory body. Here in that regulatory body, very specific things are taken into consideration. One is wherever there is a hazardous product, unsafe product for the human consumption.
The class action bit.
Class action bit, yes. So there they can, either somebody complains or even they can suo moto take action. So that is the body which is not existing, and that is a very, very positive step, I would say.
So that according to you, will become the driving force.
That will become a driving force. That has a lot of work which have been assigned to this body. This body will specifically look into the interest of the consumer. That is one major. Under this umbrella, they can even set up regional bodies. Few regional bodies, like in Madras, they propose to have, and so on and so forth. And then they will be taking out whatever is good. That is one, second body. And third is the redressal mechanism body, which is there, like at district level.
So it's a complete new setup that has been brought into motion, and that's why replacement of the earlier law.
Replacement of, and if you go in the third thing, which is the current setup, district, state and national, I'll just in very brief tell you what are the very dynamic things have been added here. Like their jurisdiction is increased.
Civil court power,
power of
everything.
And not only that, power of review is given, which is not there.
Moving on, my colleague Raj Kamal Rao spoke to Mr. Sunil Prakash, President, Consumer Forum and member, Consumer International, to get his point of view.
Government confirms and implements that the lawyers are banned from the consumer court. Because what is happening, that the lawyer comes, a highly paid lawyer comes from the side of the company. He finds some technical lacuna in the case and gets the case in favor of the company, which is deterrent to the consumer. Because he is not able to hire that level lawyers who could fight on his behalf. And if he does that even, then where is the consumer court? It is more of a civil court. So there are big need is required to be changed there, so that the lawyers are banned and the product manager should come to the court and vouch on behalf of the company. When this will happen, the company will feel the pinch, because the costly product manager who has to come there and tell about the court, tell to the court about the product, the things will improve a lot.
Thank you, sirs, for joining us on this discussion. The time for us to end the show. You can email your suggestions and comments to law@rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.